In the third week of Karen Reed's murder retrial, well, there was one witness who really said it all. And we're going to talk about that and a whole lot more in this episode of Charlie Crime Buster. It's what some people are calling, well, they're calling it the fastest minutes in podcasting.
The views and opinions expressed in this presentation are solely those of the individuals participating and do not represent those of city, county, state, or federal law enforcement agencies nor sponsors and platforms of this presentation. All individuals described or mentioned in this presentation should be considered innocent until found guilty in a court of law. This presentation contains subject matter such as violence and graphic descriptions. Listener and viewer discretion is advised.
Well, hello and welcome. If you've been following the Karen Reed murder retrial, well, this one witness just about told it all. Now, for sure, there's lots more to come. However, if you heard the direct testimony only, you would probably vote guilty. And yet, if you heard the defense cross-examination only, you would probably vote not guilty. That is how much that was covered from this one witness this week. We're going to tell you all about that in a moment, but first, let me take a moment to welcome you on board the Charlie Crime Train today. We're grateful for the thousands of downloads that we see taking place, and we appreciate each and every one of you. We'd like to invite you to reach out with a shout-out. You can reach me, charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Ask questions, make suggestions about other episodes, even lodge objections. We value your opinion one way or the other. Even if you don't agree, there's a safe place. Just reach out with that shout-out, charliecrimebuster@gmail.com. And we're grateful for our sponsor, PeacemakerNetwork.com. Please go over there and see about all the wonderful things that are happening there at PeacemakerNetwork.com. We're talking about those brave men and women of the military. We're also talking about first responders that are there when you need them, and those brave folks in law enforcement who stand between us and evil. All of it we pointed out right there on PeacemakerNetwork.com. If you have not yet joined the YouTube channel, be sure and do so. Maybe you're even listening from the YouTube channel, and we thank you for being a part of that. Don't forget to subscribe and hit like as often as you possibly can. And if you want to know where to find these links, we're going to put them all right there in the show notes. All you have to do is reach right over there and click, and you will be right there. By the way, we like to get caught up on all the other episodes, and we've done a number of episodes on the Karen Reed case, because this is obviously the second trial, so a lot more information there. Or if you'd like to join us in other podcasts, if you're a crime junkie, we got just a place for you, charliecrimebuster.com. Or go onto YouTube. We've got just about all of our episodes listed there on the YouTube channel. So thank you again for joining us on the Charlie Crime Train today. We're going to get right into it now when we get into our focus. Yes, it's been called the retrial of the century, and crime junkies, well, you were not disappointed this past week when Sgt Yuri Bukhenik took the stand. However, before he took the stand, there was another bombshell witness, Jenifer McCabe. She was concluding her testimony this week. And there was some tense words there as well. When she was faced with why she left out calling her own sister before facing the feds who were called in to investigate possible police misconduct in this case, well, she did become quite defensive. You see, defense attorney Alan Jackson pressed Jenifer McCabe on the discrepancies of her testimony. That is, during both trials. And, of course, the police interviews and phone calls and texts with family and friends. She bounced right back to Jackson and said, "There's nothing about calling my sister that is nefarious." That's what McCabe said on cross-examination. Of course, Jackson bounced right back, "Nefarious? Who's talking about nefarious? You're the one talking about nefarious. Is there something you're hiding?" That's what he referred to, basically, or inferred to, I would say. And she, of course, did not remember details regarding who she contacted following O'Keefe's death. And then she went on to say, "I feel like you're insinuating it might be, and it's not." Well, at this point, we all know that McCabe was getting very defensive about some of the questions. She was going toe-to-toe with the famous Alan Jackson. And, of course, during that questioning time. Now, Jenifer McCabe also said that Karen Reed asked her to search hypothermia, to which she entered the search, house long to die in the cold. Now, as you recall, the defense team, well, they believed that she made the search at 2:27 a.m. But a representative of Celebrite, well, he explained to the jury, Celebrite being some kind of company that researches this type of thing. Well, they explained to the jury the search was actually conducted at 6:23 a.m. Now, at this point in the trial, regarding that text, it appears that the prosecution, well, they countered that argument. And it is important, by the way, because if Jenifer McCabe made that text at 2:27 in the morning, that's what law enforcement revealed in one document during the first trial, then if that is the case, it's a big win for the defense. It backs up their theory that John O'Keefe was beat up inside of the house, brought up in the cold to die. Yet, if it was in the morning nearer 6:23 a.m., then that text is not supportive of the defense at all. Jackson did score some points, though, when he pointed out that Jenifer knew that her brother-in-law was a first responder, and he could have helped them when they found John lying in the snow. Yet, for some reason, she did not bother to get her brother-in-law on that cold January morning when John was lying there. He was trained in first aid. She didn't even contact him when a fellow police officer was found dying in the cold snow on his very front lawn. Yes, that's puzzling to many people. It's also a little bit suspicious how Jenifer and the group that were in the home that night, well, they've circled the wagons. Now, to me, this is a little more understandable because they are trained law enforcement personnel. They know in advance that defense attorneys will often target law enforcement regarding any investigation. Yet the way they've circled their wagons appears to be a little over the top. You see, I don't think anybody really believed Jenifer when she talks about, as she contacted her friends and family before talking to investigators, that she simply wanted to know if they had contacted them as well, particularly the feds who were investigating this investigation. It's hard to believe they did not discuss their own interactions with investigators. See all that to make sure that everybody's kind of, quote-unquote, on the same page. Yeah, I believe they did talk about it. I believe they did want to make sure they were on the same page. Now, you can also make the argument that just saying the same thing over and over again shows the consistency of truthful statements. In other words, if this person says it, and this person says it, and that person says it, then it must be true. But on the other side, you can also say that such statements were rehearsed among each other, and it was an intentional plan to make sure that everybody said the same thing. Well, the bottom line, as far as Jenifer McCabe in this cross-examination that was concluded during this past week, the third week of the trial, I guess we're going to have to say that Jenifer McCabe came across much better in the second trial. I believe she was stronger. But Alan Jackson made some vital points with some strong, reasonable doubt considerations. You see, to me, this is what this case is always about. You see, I don't believe that the defense will prove that John O'Keefe was beaten up in the house and brought out to the snow to die. But wait a minute, they don't have to. The question is, can they prove reasonable doubt in the state's case that Karen hit him with her vehicle, and it was there that he sustained the injuries that ultimately killed him? And it is kind of amazing that so much of this that's put on by the state and the defense, well, it can be turned right around and used to prove the opposite. Let me give you an example. The insistent calls and voicemails made by Karen over and over again to John O'Keefe during those early morning hours. Well, they certainly prove that she was angry with O'Keefe for not coming home. And you can see how the prosecution is trying to prove with these angry voicemails throughout the morning that would be a motive for Karen to have hit O'Keefe with intent. But wait a minute. Doesn't it actually prove? Well, it proves to me that she did not know that he was lying in the snow. That if she hit him, she didn't know about it. No one would make those kind of voicemails that she made throughout the night if she knew that he was already lying there as a result of her own actions. It simply does not compute. It does not make sense. You can tell she's really worried and angry and concerned that he didn't come home that night. Now, she may have hit him, but I don't believe she knew that she hit him if she did. Or maybe he was beat up in the house. That's what this case is all about. It is indeed a crazy case. And there are other things that came into the case this week. Jurors also heard from one of the partygoers inside the Albert home. That was on the night before John O'Keefe was found in the front yard of 34 Fairview Road. Sarah Levinson. She got on stand and talked about how she was there because there was a birthday celebration for Brian Albert Jr., son of Brian Albert. That was, of course, on January the 28th, 2022. She and her best friend, Julie, they arrived at the home around 7 p.m. And at some point, Julie, she called her brother. Her brother, a guy by the name of Ryan, said, "Hey, I need a way to get home." Levison and Julie decided to stay a little longer. And so then Matt and Jenifer McCabe gave them a ride home about 1:30 that morning. But now get this, Levison said, as she left that home, she did not see John O'Keefe in the front yard when they left the home. Well, you say, but it was snowing. Yeah, but there wasn't that much snow at 1:30 a.m. in the morning. Not that much snow that it would have built up a snow mound that you could not see John O'Keefe. So why did they not see John O'Keefe lying on the front yard if he was hit by Karen's vehicle? Could be that they were just looking down at their feet, make sure they didn't slip and slide while they're getting in the car, or it could be that John O'Keefe wasn't there. Now in a moment, we're going to get to the witness. The witness that told it all. The witness that I talked about at the very beginning of the podcast that I said, one witness tells it all. But now let's just take a moment and let's take a break and let's take a big breath. And let me share with you Charlie Crimebuster's Crazy Crook of the Week. Now when it comes to crime in this country, it is so tragic that people forget manners and decency when dealing with one another. I really get tired of reading and hearing about people who lose their lives because other people do not have emotional maturity or emotional strength. That is, enough emotional maturity and strength to control their own emotions. It was just yesterday. I read again of somebody who was shot and killed over a simple parking place. Can you believe it? Think with me. Think with me about this. All because you can't keep your emotions in track. You shoot and kill another human being over a parking place, leaving perhaps a family behind without their loved one, a wife without her husband, a husband without his wife, a child without a father. And then you turn around and ruin your own life by going to prison for the rest of your life over a freaking parking spot. Well, I guess with that in mind, it should not surprise us about our crazy crook story this week. Now, thankfully, this one crazy person who had no emotional maturity did not end up with someone dying, but we have entered her as a crazy crook simply because of her own crazy behavior. And it was all seen in shocking footage of the moment a North Carolina woman lost control of her car at a Chick-fil-A drive-thru. It's going viral. The video, it was posted to TikTok on Wednesday by a person by Southern Spice 82 who wrote, quote, she stepped out of her car to argue with an employee and left her car in drive. Well, thankfully, no one was hurt. Now, that post, by the way, has amassed over 5 million views and thousands of comments. One viewer said the incident was an act of, quote, unquote, karma. Well, how did it all start? Well, the video was being filmed from the second car in line at the drive-thru. It starts in the middle of an argument. This white sedan, well, this lady got out of it, and then it could be seen beginning to roll away from the commotion on a busy crosswalk. "This is why we're concerned, ma'am," yelled one of the restaurant's employees, as you can see this woman chasing after her car as it's rolling down the street. Well, for a few moments, everybody just watches as the woman tries to catch up with her vehicle. At one point, somebody says, "Call the police." But once the sedan hopped the curb at the end of the driveway, trampled a few small bushes, it disappears, well, off the lot's retaining wall. 2 employees then chase after the woman, tell her to get away from the car. Well, the woman did. Well, she did indeed manage to hop back into her car before it crashed. That's what NBC affiliate station WECT said. And fortunately, she wasn't injured in the accident, but her car, well, it was totaled. So this crazy lady, who has no emotional maturity, had to get out of her car to yell at a fast food worker, only to see her own car going off the embankment there and totaled. She is indeed Charlie Crimebuster's Crazy Crook of the Week. Well, now back to our main focus. Probably the most intense cross-examination in the trial took place this past week, the 3rd week. It appears one of the ways that the prosecution, well, the way they want to ignore the elephant in the room. Now, when I say elephant in the room, I'm talking about Proctor, the chief investigator, who was disgraced and fired. Well, the way they want to ignore it, it appears to use the sergeant who was over Proctor, Sgt Bukhenik, to take our mind off of this infamous fired trooper. So as the state uses Bukhenik to try to lay out their case, they also take time to run over the fact that the investigation had a black eye with Trooper Michael Proctor. Brennan even had Bukhenik read some of those terrible texts that Proctor communicated with himself and others that showed his own bias in the case. You remember those, don't you, from the first trial? If not, go back to charliecrimebuster.com and get caught up. To be sure, it was obvious that Proctor should have never investigated this case. Now, keep in mind, he did make these terrible texts on his own personal phone. He did not use the work phone. And I bet you for sure he never thought for one moment that these texts would become public knowledge. But as James, our own producer here at Charlie Crimebuster, and I have said from day one in our podcast, we all leave digital footprints all day long. You may be asking how his personal phone came up in this investigation. Well, we all know now that the feds, the Federal Investigations Company, the FBI, launched an investigation into how this case was investigated. Therefore, Proctor's own personal phone was searched with a warrant. Now, anytime you hear this other agency mentioned in this trial, the other agency is the FBI. Now, they can't say that in the trial because of the fact that that is prohibited by the judge from coming in as far as the name of the federal agency. So Brennan decides to air his dirty laundry himself instead of giving, of course, Jackson an opportunity to bring it out first. He does that by putting Proctor's own supervisor on the stand in Proctor's place. This is the guy who literally says it all. It appears to me that he has no real plans to call Proctor, unless he changes that in the days ahead. He even had Bukhenik tell the jury that he himself was disciplined. In other words, Sergeant Bukhenik was disciplined himself for allowing Proctor to send those terrible biased texts, which he himself responded with a thumbs up. So now you can imagine how the cross-examination is going to go. Well, there are some gotcha moments for sure on both parts. And since most of the time this week was used with Jackson on cross-examinations, we're going to focus on that. There's simply not enough time to go over all of this week's trial in this time-limited podcast, so we're going to hit the highlights. For sure, Jackson has pointed out possible doubt in just about everything the state has put out in this trial. The question is, will the jury come to the point that they feel the doubt is reasonable? You see, it is reasonable doubt that you have to prove it, not just doubt. I mean, everybody has doubt, but is it reasonable to doubt it? If it's reasonable to doubt it, then they can't really vote guilty. And what hurts the prosecution is the many, many mistakes investigators have made in this investigation. Had the case been investigated professionally, there is a good chance that there would not have even been a second trial. On top of that, the prosecution did an overreach on the charges. That's very evident to me. So now I'm going to simply share with you what I've noted in my own notes regarding this week's trial. I'm going to share it with you. I believe the state did a decent job in refuting the defense's contribution that the text that Jan McCabe made on "How's long to die" in the code was made at 2:27 in the morning. By bringing their own expert to indicate to the jury that the timestamp was simply when the Safari search tab was open, which is 2:27 in the morning. And we also got to remember that there were other things that was searched during that time in the morning. I believe that's a plus for the prosecution. I mean, why would you search about sports if you were just texting about how long to die in the code and you thought that John O'Keefe was lying on the lawn? You see, they're alleging that that tab was simply left open. And then it's reasonable then to believe that the search could have been made, as Jenifer McCabe testified, at 6-something in the morning instead of 2:27 a.m. Now, many of us have left search tabs open to search something else on the tab later on. I think that this will indeed resonate with the jury. Of course, the defense, they're going to come back and say, well, it could have been made earlier as well. So I believe this is going to kind of be a washout in the jury. I do not think that it enough of itself will lead either way in the jury's mind. Of course, some might be thinking, well, why don't they bring an Apple expert on since it was an Apple phone? Have you ever thought that? But another plus for the prosecution is the broken pieces of taillight that ended up on the lawn at the house where O'Keefe was found. We all know by now that the taillight appears to match with Karen's car. But at the same time, the defense is putting before the jury, through questioning this witness, Sgt Bukhenik, that the investigation is blotched and Karen is being framed and that O'Keefe was injured in the house and placed outside. So in looking through my notes, I noted that Jackson scored big when he got Bukhenik to admit on the stand that a video earlier that morning showed, before they found John's body, shows Karen backing into what appears to be Karen backing into John's car as she backed out of the garage as they were trying to find John, and is alleging that this is where the taillight was cracked and not at the scene where John O'Keefe lay. Now, Bukhenik, he admitted on the stand that he did indeed see the wheel of John's car move, indicating impact with Karen's car early that morning. Now, of course, the prosecution is saying that even though there was impact, they're alleging it wasn't hard enough to cause damage to her taillight. But in my mind, and your mind, we have to ask the question, could that put reasonable doubt in the mind of the jury as to where that damage was caused? And Jackson also scored big when he asked, when the investigators saw the broken taillight earlier that day, why didn't they take pictures of it with their own phones? You see, there's a big difference in a cracked taillight and a broken one. And there's also the fact that earlier searches did not reveal broken pieces of taillight on the lawn. I believe also now, on the other hand, that the prosecution scored points with the missing sneaker of John that was found on the lawn. Those of us in law enforcement, we know that often accidents involving a pedestrian and a vehicle, people are literally knocked out of their shoes. Of course, let's go back to the other side. Seasoned law enforcement, they know that for a fact, and they could easily have said we ought to plant a shoe to put more frame on Karen. So another major point for the defense was this. Get this. No taillight pieces were found in the early searches. Now, to be sure, there were lots of snow on the ground in the early morning hours. However, the defense is also able to point out that, quote, unquote, no taillight pieces were found until after Karen's vehicle was in police custody. Never found it before her vehicle was in police custody, even though there were other searches. So you see, the defense, I believe they're making some really good points on cross-examination with this one witness. We're having the prosecution for sure laying out their case, but the defense is coming back and poking holes in it, one after the other. But I want to share with you what I feel was really a great strategy by the defense. In the first trial, text messages between Karen and ATF investigator Brian Higgins, who was in the house that night, was shared by the prosecution. Many of those texts were handpicked by the prosecution to prove that Karen was flirting with Higgins while still John O'Keefe's girlfriend. Even texts that said he was hot and she wanted to hang out with him. This by far made Karen look bad in front of the jury. But now Jackson turns around during this trial, and instead of allowing the prosecution to use these texts, he used Bukhenik to read these texts as testimony that would bolster the defense. This time they did not pick out one or two, but he let all the text go for itself. In other words, it wasn't cherry picked, but you saw the entire context of the text. And in that entire context, you see that Higgins was also pursuing a relationship, even though he knew that John and Karen were boyfriend and girlfriend. And a cop going after another cop's girlfriend, well, it's not a good look at all. On top of this, Jackson was able to show that Karen had moved on, was actually ghosting Higgins, which could have led to Higgins having a motive to get in a fight with John that night at the house. He then had Bukhenik to admit that Higgins was a trained veteran with hand-to-hand combat and that he and Albert were in quote-unquote fighting stands at the bar earlier that night. It was a beautiful job of taking a strong presentation by the prosecution in the first trial and turning it into a strong presentation by the defense in this trial. This was the way that Jackson was able to introduce to the jury, even this early into the trial, a possible third party as being responsible for O'Keefe's injuries. We call it the SOD method, S-O-D, some other dude. Some other dude did it. And then Jackson pounded on the poor investigation. None of the possible suspects of the fight were investigated by the state police. The house where the alleged fight could have occurred was not searched. Evidence was not properly gathered. Evidence was not properly stored. Evidence was not properly logged. Evidence was not properly photographed and are described according to investigational standards. Report writing was poor, not punctual, sometimes non-existent. Some reports were delayed in writing. One such report delayed over 500 days, and up to 20 reports were delayed way beyond a reasonable time. The investigation was by far not a model investigation, and Jackson is using it in every way possible to drive the reasonable doubt train down the track. Now, my friend, in old Tennessee slang, it ain't over. There is yet to come a whole lot. There is the battle of the experts, and there are still questions to answer. Will the prosecutor put Proctor on the stand? And if not, will the defense? We do not know at this time. Will the prosecutor put Brian Higgins on the stand to defend this theory that the defense is alleging? Will they put Brian Higgins on the stand? Now, I doubt the defense will put him on. I mean, they've already succeeded in making him a possible suspect. If they were to put him on, they would risk maybe the jury being charmed with him and think that he could not possibly do this. So will then the prosecution bring him on and allow him to be cross-examined by Jackson? And if they do, how will they handle the fact that Higgins destroyed his own phone SIM card on a military base? And how about Brian Albert, the same owner of the home, a fellow cop who did not come out of the house that morning even though a brother cop was lying on his lawn dying? The same Brian Albert who sold his house, destroyed his phone, gave away his dog, and re-floored the basement of the house where the defense is alleging that John O'Keefe was beat up. All of that could be answered. They could be an answer for every one of those questions. But will they bring them on and allow Jackson to cross-examine them? And if they don't, will Jackson call any of them? So many questions. And still, don't forget the battle of the experts, where they will spar over the fact of John O'Keefe's injuries. Were they caused by the vehicle or by a fight and a dog? Well, much, much more to come. So, my friend, until this time next week, Charlie Crimebuster reminding you, be safe, be alert. For the life you save, it may be your very own.
You have been listening to Charlie Crimebuster. We would like to thank our sponsor, the Peacemaker Network, and also encourage you to support the first responders, military, and law enforcement personnel by contributing to the Peacemaker Network. That's peacemakernetwork.com. peacemakernetwork.com. You can also support us by subscribing to our YouTube channel, tag @CharlieCrimebuster. And once you arrive there, click the subscribe button. By doing so, you'll be notified each time we drop one of our shows. Another more convenient way for you to listen to our podcasts are for you to say to your smart speaker, play Charlie Crimebuster. If you have comments or suggestions, we would love to hear from you. So please send them to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Or you may call or text us at 407-917-2211. That's 407-917-2211. Thank you for joining us today, and we hope that you will join us next week for another exciting crime story with Charlie Crimebuster.